Friends, today's topic is personal data protection law, a game changer. It is not just timely, but it is also transformational. In the world where data has become both currency and identity, the way we collect, process, and protect personal data will shape the future of governance, business, and society. With the introduction of Digital Personal Data Protection Act 2023, India is stepping in a new era, an era where data dignity and digital trust become national priority. And today, data is a power, data is economics, and data is acceleration. In today's digital era, data is one of the most valuable assets for business, government, and individual. With the exponential rise in the data breaches, cyber threats, and privacy concern, data protection has become a critical focus for organizations globally. Regulatory frameworks like the General Data Protection Regulation, called GDPR, and Indian Digital Personal Data Protection Act 2023 have put pressure on corporate to enhance their data protection practices. Data protection is not just about compliances. That is very clear, and we should understand this. It has becoming a fundamental business strategy that can influence the company's reputation, customer trust, and operational efficiency. Because when we talk about the data protection law, everybody thinks this is a compliance. No, it's not a compliance. It's in our strategy and embedded in your whole strategical part. And friends, in today's webinar, we will explore why data protection is a game changer for modern organization and how adopting robust data protection measures can significantly impact business continuity, customer relation, and regulatory compliances. Because business continuity means if you fail, your business can stop. Customer relation, if you leak the data, the customer relation will destroy it. Regulatory compliance is also because all these two things, it is not only self-destruction also, but you will face regulatory compliances also. Data protection is no longer just a legal or IT issue, because somebody thinks that data protection is not I'm in corporate law, so what is the connection data protection? Some IT person or IT team has to see. No. For IT issue, but a strategic business priority that impacts organizational reputation, customer loyalty, and operational resilience. This is now all three integral part. By implementing strong data protection practices, business can migrate risk or business can mitigate risk, ensure regulatory practices. Business can mitigate various issues and gain a competitive advantage in the marketplace. This webinar will provide valuable insight on the recent data protection regulation in India and how organizations can adapt to the changing landscape of data protection regulation in India. The law is much more than the compliance requirement, which I have told you just now. If implemented effectively, it has the power to empower individuals with control over their personal information. That is one of the larger part of the law, and which is connected to each individual. Enforce accountability amongst organization, because all organization has to follow some rules, regulation, and they will be more accountable, which we are seeing. People are just, we are getting information that somebody has sold the data of mutual fund, data of this organization or that organization. So that is also making the organization accountable, that it is not that you should leave and you should say that something has missed out. Enhance cyber security. So you have to do this, that how the cyber security can be more stronger. And position India as a global trusted digital economy. Because if our data protection law will be weak, then in the global digital economy, our role will also be weak and we will not be identified or reckoned with power. While it draws inspiration from global standard like the GDPR, which I have told you, it is tailored to our unique digital landscape, because in India, UPI today, nobody's taking cash in their pocket. They are using digital. That is a remarkable change which has come. Now behind this, there is a data also, because everybody who is using this, one is identity that I'm using, then my data, how I'm using, where I'm spending, all these is a information, which is very, very crucial and very, very personal. Yes, there are concerns about government exemption, enforcement, independence, and clarity on rule, right? But these are part of the evolving ecosystem because it's a starting point where public dialogue and stakeholder engagement will play a crucial role, which we are doing today. We are creating an awareness, and then this awareness will help to realize the importance of this law. As a I'm as a professional, we must look beyond checkbox, because when we saw compliances, we do the checkbox thing. The future, because I told you this is not a compliance, this is a strategy. It's not a checkbox that you have done this, you have done this, you have done, but you have to make a strategy that something will not be missed out. The future belongs to those who embedded privacy into their culture, product, and policies. That is also very, very important. Understanding CPP, where compliance meets consensus. Now, today's program, we will discuss introduction of data privacy evolution, global privacy principle, digital personal data protection 2023, and data protection, draft digital personal data protection rule 2025, privacy in the organization, data privacy compliance tool. And these all things we will discuss, and then we will have a question answer. Before I invite our guest, or I should give a just introduction of them. Friends, as you are aware that we have invited Mr. Amar Patnaik for today's program, but suddenly there was a meeting of the Tamil Nadu Chief Minister related to delimitation and other things which is happening. So Amar Patnaik has gone to Chennai, and he is in the flight, and he is representing his party. So and because he was a joint member of Joint Committee of Parliament, and he has spoken earlier also. So we will miss him today, his expertise, but he has promised the next time he will definitely join. Then we have none other than Pawan Duggal, Dr. Pawan Duggal. He is a name in the data, cyber security, or wherever anything is coming related to the digital. The Pawan Duggal name, Pawan Duggal is everywhere. So he's a founder and owner, Pawan Duggal Associate and Head Artificial Intelligence Law Hub. He has been practicing as advocate in Supreme Court of India for over 2 decades, has made an immense impact on field of cyber law and law related to e-commerce. He's in all committees, he's invited in all type of program whenever there's a cyber law is involved. He is the founder of chairman of International Commission of Cyber Security Law. He has been acknowledged as one of the top 4 cyber lawyer around the world. That is a credit to Pawan Duggal. And he has not only this, he has spoken more than 2,000 conferences, seminar, workshop, and he has lectured extensively in select law colleges. As a writer, he has made his mark with 154 books on various aspects of law. He has been contributing a continuing weekly column titled Brief Cases in Economic Times for almost a decade. I welcome Pawan Duggal. He's just joining because today the Delhi Bar High Court's election is there. So he's there and he's just joining within few minutes. Then we have Ms. Nikita Kothari, a partner, corporate professional in Nagpur branch. She is chartered accountant and qualified DSCI certified privacy professional and work in this data protection law, which is very niche area. And you can understand how the people are shaping their future in this law. She's a chartered accountant, but she realized the importance of this. So we will listen to her comments, her part on this. Then we have a Chintan Suryavanshi, a associate corporate professional in Nagpur branch. He is chartered accountant and certified information privacy professional done from Europe. So Chintan will also share international experience about the rules, about this law and detail and how this can impact. Then we have Ravi Prakash, Associate Partner, Securities Law and Corporate Litigation, Corporate Professional. And Ravi will discuss the case law which is happening today and which can connect you about the law and its importance. Yesterday, I was reading one article on in our college day, we were reading sine theta and cos theta. So one question was coming that, have you ever used sine theta, cos theta? But yesterday there was an article and they say everywhere sine theta, cos theta is used. Only thing is that you are not aware of this. Even when this just now America has done this, and our astronaut has come to India. That is also used in the car also, that is used in various things. This is used. So Ravi, when we'll discuss about the specific point relating to this, then we will understand that how this data law is very, very important and it is connected to everyone. Friends, before I'm giving some few more comments, our next webinar is on 28th March. That is on the recent SEBI has come out, the faster right issue, redefining capital raising by listed company. We will do this on the next Friday, that is 4 p.m. That we will do. And today's program is structured like this. First, Mr. Pawan Duggal will speak, and he will tell about this law and prospect. And then Chintan will speak about introduction, evaluation, and principle of this law. Then Nikita will discuss data protection rules and privacy in the organization. And then the Ravi will speak about the case law and various important aspects. Now, friends, as you are aware that this law is very, very different, and people should not confuse with the just it is a compliance. It is a right of is a strategy which every company has to follow. Future aspects beyond compliance is also there, because this DPDP 2023 is just a beginning in India. It's stepping into an era where data fiduciaries will be evaluated not only on profit but on the privacy ethics. Future audits, ESG rating, even investor sentiments will be influenced by how companies treat personal data. Now, imagine a world where citizens have data vaults where AI recommends privacy setting, and business compare with the trust as a currency. We need to think beyond what the law mandate and move towards building privacy first organization. Now, when we will discuss all these things, and when we say the topic is the game changer, personal data protection is a game changer. So now why this is game changer? What is a personal data protection law? That they will explain to you in detail, but collection, processing, storage, and sharing, these are the concept of the entire law, and you have to protect all these things. When you collect, when you process, when you store, when you share, all these things should be go to the concerned person, not others. Why it is needed? Because data exploration is taking place. Data is now money. Every day, whenever you are joining any company, any website, any app, they are asking information. Now they are asking your personal information. And when you are opening a bank account, opening a share account, opening anything, you are using the same data and using the password. So the cyber threat is also there. So this data should not be utilized by some other thing. Cyber threat is increasing day by day. Leaks, credit bureau hacks, all these things are happening. So if somebody hacks your data and get all the relevant information, and then he can take out your money from the bank, other things. Lack of accountability, because people think data isme kya chori hai? But this is also a very, very important thing. Global trend and compliances, because when you become party of the digital system, the entire world is connected. So you have to see the global trade and global compliances you have to follow. So it is essential for national digital sovereignty as well as trust-driven digital economy. Because if you have no, because sometimes when I'm using any app and they are asking my email password, I don't fill this. Because sometimes you should have a trust also. And if somebody is using this, then you lose the confidence and then lose the confidence of that brand also. Now, the key feature of DPDP Act, which Chintan and Nikita will explain to you, this consent-based process, right to individual data fiduciary, significant data fiduciary certification penalty. Now, this is very important, and I request Nikita and Chintan must say that the amount of that penalty is 250 crore. That is also people should realize. Your organization may be small and you are collecting data of your client, data of people, and then you are leaking out and your system is so easy, then you can understand the entire business can collapse. Then status in other jurisdiction of global comparison, that is also very, very important. India has to be part of this. Europe, they have come out the GDPR benchmark law in 2018. They are also very strong right and heavy penalty. They're up to 4% of global turnover. Just imagine. There's an X company which is across the world and there are 4% penalty on global turnover. So Europe is also very, very strong. USA, sectoral approach, HIPAA for health and GLBA for financial data. No federal law yet. State like California have comprehensive framework, but all other state has. Heavy focus on customer rights and transparency. In China, though China name comes, then we also think how independent, but personal information process is also there in China also. It's still data localization, cross-border data transfer rights, and emphasizes state oversight and cyber sovereignty that is there. Singapore, they do PDPA, encourage compliance while a lighter touch regulation and focus on business entitlement and trust and accountability framework. India has an opportunity with DPDP Act. India is creating a hybrid model that borrows from global best practices, but is also tailored in India, scale, diversity, and digital public infrastructure like Aadhaar, digital locker, and UPI. Now you are keeping everything in digital locker and somebody is taking out, you can understand your entire thing is out. And this is the foundation law and the global league we have to reach on this. Now, one issue is coming that people are saying opposition parties and other people, civil societies opposing this. The question is why? Because so I identified and my team has given me this particular suggestion, then overboard exemption for the government, that is one part. Weak data protection board, because they say impartial enforcement should be there. No right to forgotten or data prohibitivity. Vague terminology and definition on something public interest, legitimate use. Then cross-border data transfer, that is also issue. Lack of clarity on children data. Then opposition from civil society also on this aspects. And they talked about EFF, Electronic Frontier Foundation, and Indian Privacy Group are opposing, more aligned with surveillance interests. Lack of transparency in drafting, because they say there are so many problems in this. Global concern is also there because EU international privacy advocate are watching closely. If the law is not seen as adequate under EU standard, data transfer from the EU to India may be restricted. So this is also one of the biggest thing. And foreign company worry about legal uncertainty and compliance complexity, especially when data process span jurisdiction. Now, these are the points where people are opposing. But the question ultimately at last, how the positive outcome will be of this private data? Number one, empowered individual. Privacy is a right that is established in this. And whatever information somebody is sharing, it is his or her information. You can't misutilize or utilize where I have not instructed. Responsible organization. Second is all organization will become responsible because penalty is very, very specific. You have to use the data for a specific purpose for which you have taken or you have been authorized. So the data collection and data minimization, this is necessary. So that mindset has to change. So corporate world has to understand, and the penalty which is there, because this law, no penalty has imposed publicly on a companies, so people are not realizing. But when some penalty or some case will come, then they will realize. Boost to global trade and digital economy. That is another aspect, because when you will follow GDPR law, then more economy and more e-transaction will take place. Strengthening cyber security framework, because all these things, cyber security will also increase. Encouragement for digital innovation and trust tech, because that is also important. The digital transparency, digital innovation, digital trust will also going up. Accountability and governance culture will come. No doubt, governance culture is a part and parcel of companies. They have to follow. But accountability of data protection is also very, very important. Privacy becomes a boardroom issue now, just IT room or IT department. So every board has to make risk factor, and the data protection law is a part of this compliance. New compliance ecosystem, like new role of chief privacy officer, privacy consultant, data auditor, creation of privacy compliance framework, certification and audit mechanism, legal and consulting opportunity will also be there. So that is a game changer. Now, if this particular law is implemented with accountability, this law can lay foundation for the data trust economy. Because when my economy is becoming a database or digital base, then there is a need of trust also, where innovation thrives not by exploiting data, but by respecting and safeguard it also, because you are taking somebody's data on some trust. India can become not just the largest digital democracy, but also the most trusted one in the world. So friends, this is my opening comments. And now Pawan Duggal has joined. I have given introduction and I told you everybody wants to see his view. So Pawan, can you just start this topic and give your valuable comments on this? Pawan, have you joined? Yeah.
Thank you, Pawan Bhai, for giving me this opportunity. Good evening, everyone. It's a pleasure to connect up with all of you. Today, when I talk about the Digital Personal Data Protection Act 2023, I get surrounded by various thoughts. First, will it ever get implemented? Why? Because it's continuously being pushed, postponed, and people don't exactly know whether it'll ever come into force or not. Now, this uncertainty is not because of any political reason. This uncertainty is because of a distinct provision under the DPDP Act, which clearly says that the central government may, by notification in the official gazette, notify different sections and provisions of the DPDP Act for implementation. So right now, the government has recently closed the public comments time frame for the draft Digital Personal Data Protection Rules 2025. And we are soon going to be expecting these rules to be put in place. So for those of you who are thinking the Data Protection Act is not coming, or that the rules will take a long time, we really want you to think again, because it's round the corner. Number two, why do I need to look at my compliances under the Data Protection Act is the second question. Because everything is uncertain, it's in a state of flux. And everybody is saying, I will wait. Let me wait on the fence. As and when the rule comes, only then I will be able to implement or do my compliances. I think that is not a very correct approach going forward. Why? Because the law has already been passed by Parliament. The Digital Personal Data Protection Act, or the DPDP Act, is already in place. Now, it's only yet to be implemented. This particular law will now not change till such time it's either amended, revised, modified, annulled, or repealed by another act of parliament. Right now, there's no other act that we are potentially seeing on the horizon. So, if we are thinking that we'll wait for the rules to come and then start complying, let's have a fundamental clarity. The rules are only providing procedural safeguards or for actual implementation of the provisions of the law. The provisions of the DPDP Act are not changing. So if you think that you want to wait till such time the draft rules comes, I believe you are effectively only trying to play with. Why? Because you will not be in a position to do your compliances in time. Yes, the government is going to give an interregnum period to enable you to comply. But because everybody else will be in the same mode, same rush, there may be chances that because of business or other exigencies, you may not be in a position to go ahead and do your compliances. Number three, why is it so important for you to comply? Why? Because there is no penal provisions, no data crimes that's defined under this DPDP Act. And therefore, why do I need to bother? Because I'm not going to go to jail. Little do you realize that this new exemplary remedy of fines up to 250 crore rupees is not a child's play.
Yeah.
The law says fine up to 250 crore rupees per one contravention. So if there are 4 contraventions, be prepared for 1,000 crore rupee corpus. A lot of people are saying, well, the law is talking about completely unrealistic figures. Nobody has got 250 crore rupees as loose change. So nobody will be able to pay. So why even bother? What we are missing the point is that this monies of 250 crore rupees are not going to any private individual. They are also not going to any corporate, not to any other institution. They are payable directly to Government of India in the form of payment to the Consolidated Fund of India, which effectively means that if you don't pay the government, the law is very clear. The law considers this as arrears of land revenue, lagan. And the government has been given the power to attach properties, sell properties, and lo and behold, sell the properties not just of the company against whom the fine has been imposed, but even attach the properties of the top management. Why? Because the law is very clear. If a contravention is committed by a company, then every person responsible for running the day-to-day affairs of the company or management of its day-to-day activities shall also be deemed to be guilty of the said contravention, and therefore are liable to be proceeded against accordingly. So if we want our assets to be in place, if we want our assets not to be attached or sold, then I think we need to take DPDP more seriously. But apart from all this, I have a bigger problem. I have a social, reputational problem with DPDP Act. Once a complaint is filed against you that you have not complied with the provisions of the DPDP Act, with the Data Protection Board of India, that opens up a series of triggering new processes. Number one, the complaint will be filed against your company, against yourself, to the Data Protection Board of India. Number two, the Data Protection Board of India will not have any physical office. They'll have a digital office. Number three, the complaint will be filed digitally. Number four, the complaint once filed gets converted into a government file. Number five, once a government file starts against you, I don't know how long it's going to take for the file to get completed. Number six, the Data Protection Board of India, once a complaint is filed, is duty bound to adjudicate the contravention. And should it find that you have contravened the provisions of this law, then lo and behold, it's duty bound to issue fines. the minimum fine that the law wants the Data Protection Board of India to levy is 50 crore rupees. The band starts from 50 crores and goes up to 250 crores. So you can celebrate in the interregnum that nothing is happening, but these are the winds of change. These are blowing slowly but surely. And therefore, I think you need to appreciate that we will have to be very, very diligent when we are in the direction of looking at DPDP Act. The first thing, please don't take DPDP Act very, very lightly. It's bound to create a huge hulchal in your business operations, in your personal lives. And if a complaint gets filed against your company, and the complaint then tends to get reported, then it's going to trigger off large number of reputational damage ramifications. Your reputation is going to go into tatters. People will consider you as unsecure companies. People may not want to join with you. You are not likely to get any governmental contracts. There could even be a potential blacklisting of you. And more significantly, then this is going to be a slur, a dag on your reputation for the next many decades. So whatever goodwill that you prepared all these years because of your hard work, of your good work, may go down the drain if you are not compliant with the provisions of the DPDP Act. Further, once a complaint against you starts and you are a listed company, it could have a direct impact upon your listing of share prices. Number two, you get exposed to further regulatory scrutiny. You will be now required to not just report your data breach to the Data Protection Board of India. Your data breach will also constitute a cyber security breach and cyber incident, and will have to be mandatorily reported within 6 hours to the nodal agency on cyber security, being Computer Emergency Response Team of India. You will also be required to give a detailed, comprehensive report about the personal data breach within 72 hours to the Data Protection Board of India. And it's going to even potentially impact your legal standing as an intermediary. Look, you are a company. You're dealing with third-party data. You become an intermediary under Section 21W of the IT Act. That being so, the law under Section 79(2)(c) wants you to exercise due diligence under the Information Technology Act 2000 when you are discharging your obligations under the law. So in a scenario like this, your potential exposure to legal liability is going to be massive. You'll have to realize that you may not be able to get the statutory exemption from legal liability, which effectively means that your company will now be exposed to unlimited damages by way of compensation under Section 43 and 43A of the IT Act. You are also going to be exposed to various criminal ramifications under the Information Technology Act 2000 and also under the Bharati Nyaya Sanhita. So all said and done, it is going to be a recipe for disaster waiting for you in case if you choose to take this lightly or in a halka manner. If you treat the DPDP Act in a halka manner, think that the law is now going to deal you in a very, very halka manner. So I will suggest, please get your documented compliances. Today, we have begun doing so many of these gap analysis. Companies have at least begun saying, let's do the gap analysis to find out how much compliant are we in respect to the said stuff. If you are compliant to up to a limited point, at least let's identify the gaps, and on that basis, let's try to fill those gaps. So if you have not yet begun doing your compliances, we'll actually encourage you to please look at doing your compliances under the DPDP Act. Otherwise, please remember you are playing with fire. You are bound to get burnt. What are we saying? We are saying please get a good fire suit, so that with fire all around, this fire suit is going to prevent you from getting burnt, from being exposed to heat. And this exposure to heat is going to be a long-term exposure to heat. Your long-term ramifications it's going to impact your current business operations, your future business prospects, your future business operations, and maybe your future as well. So I think all said and done, it's one of the most game-changing legislations, the DPDP Act 2023, that have come into force. It's much, much bigger, much, much stronger, and will be completely transforming the data economy in the Indian context. Mind you, this is even more stringent than the General Data Protection Regulation of the European Union. Mind you, do not be under the complacent opinion that in India, cases take years. Here, ultimately, whether any fine is levied upon you or not, you will be declared guilty and hung even before your trial starts. Because the media is going to do your trial. People will already perceive you as being insecure, as being not relevant, not reliable, and hence people will actually shudder, hesitate to do business with you. Hence, compliance with DPDP Act and the DPDP rules, as and when they come across, become of crucial necessity. It'll even be also important that please also do documented compliances under the Information Technology Act 2000 and rules and regulations made thereunder. And in case if you are using artificial intelligence in your office, think again. Your artificial intelligence program or algorithm will also have to ensure that you do compliances with the provisions of the DPDP Act. If your AI program is non-compliant with the provisions of the DPDP Act, because you and your officers in the company are using the said AI program, you are going to be responsible and you could potentially be exposed to legal remedy, legal exposure of fines up to 250 crore rupees. You can't say, look, I'm using ChatGPT or Copilot, and if something has gone wrong, they are responsible. You are the guys who are using it. Please read the terms and conditions of these AI platform service providers. They are categorically saying, whatever data you generate on my platform belongs to you. Whatever liability is that of you. We are giving you the platform on an as-is, where-is basis. So please be very, very careful. Exercise due diligence. It's better to err on the side of caution rather than go ahead and be adventurous. And my two bits of advice: being adventurous is going to be pathetically disastrous for all organizations as they move forward. Hence, proactive compliance with the provisions of the DPDP Act and the DPDP rules could be your best bet forward for a secure, robust, and resilient cyber future. Thank you, ladies and gentlemen. It's been wonderful talking to you.
Thank you, Pawan Bhai. Very nicely explained to this part, and the way you have command over this subject, no one has no doubt. Your presence is and your word of wisdom is meaningful for everyone. And the important thing which you have mentioned, that people think bhedi aaya, they just say okay, it is not applicable for every time. So tell me just because this is a very simple point. One person asking, it has been implemented so far. Rules are under process. Am I right? Or what is the status?
The DPDP Act has not been implemented so far because the government is in the process of finalizing the rules. As and when the rules get notified, portions of the DPDP Act are going to be getting notified. I expect the portions pertaining to notice and consent to be notified earlier, so that people will have to be compliance. I think a small interregnum period is going to be given for people to comply. And the more contentious issues pertaining to age gating or age verification may be implemented a bit later. Maybe more time could be given to people in that regard. But we don't have much time. The clock is ticking. And if you can actually believe this one of the statements that's given by the minister, he wants everything bound up to be totally in place by the end of 2026. So effectively, we have less than about 18 to 21 months to do everything. And it's not easy. It's going to take time, effort. So the quicker I begin starting my race, the earlier I'm going to reach to the goal post, and the more well-equipped I am going to be in terms of protecting my legal interests and those of the company. Thanks.
So the point is, we always try to proactive for our webinars, and this is in the same direction that people should realize that this is the law which is coming. This is the law which you have to take seriously. This is the law which is not a 5,000, 10,000, 20,000 or CCI 10 crore penalty. It is a penalty of 250 crore for each violation. So you can understand a company of 50 crore rupees business or market valuation, and you are imposing a penalty of 250 crore, up to 250 crore, whatever the law finally will come, it will destroy your business. So this law non-implementation is not that, okay, you will take care of risk portion. It is not the risk, it's a destruction of your business. So one should take it very seriously. The law, one day it has to come, because India is becoming a digital economy and it's growing with the pace which no other country is doing. UPI we are seeing everywhere. A rickshawala, a small, uh, even I went to Bombay. So you have seen on the Marine Drive there are so many malish wala people are moving around. So these people are having, they are just using their heads, the hands to do the malish. But when you say money, you don't have cash, so they will have a UPI. Their barcode is there. You can pay. So you can understand the how much penetration has taken place, and even sometimes beggars are also using barcode nowadays to pay this. So uh, when this type of economy is taking place, digital economy, you can understand the infrastructure and its repercussion. One should be very, very clear. I think, yeah. So what I'll do, Pawan bhai, I will request now Chintan to tell us about the evolution and principle of this law. Then Nikita will talk data protection rules and privacy in the organization, and then we'll question answer. So that time you can again rejoin, or you can.
I will rejoin again. I'll definitely rejoin again.
Yeah, I know you are out of the office, so I can.
But I'll join.
Yeah. So 5:30, you please rejoin. Okay.
I'll join. Thanks.
Yeah.
Thanks. Bye.
So Chintan, please tell us about the evolution and principle of this law.
Okay, so meanwhile, I'm requesting Nikita to portray the presentation. I believe, yeah, okay, thanks. That's great, Nikita. So very grateful for having me on the panel, and thank you so much, Pawan sir, Pawan Kumar, as well as Pawan Jugal sir, for getting everything sorted and keeping up the intensity of the webinar and letting people understand in what way this law is going to be a real game changer, talking more intensely about penalties and so on. So moving towards the part and understanding what exactly, we'll start with the part of data privacy introduction. So what exactly would got the data privacy with us, and what exactly, why are we dealing with digital privacy? So taking up the benefit of what we have, a metaphor going around that the data is being a new oil. The amount of money, the amount of cost, amount of evaluative the oil barrel used to have a decade ago or a few decades ago is what data processors now. To take care of this data and have this data in proper place, having control over the processing, collection, as well as storage of this data, we have this data privacy getting into the picture. Also, when we talk about the data privacy, the Article 21 of the Constitution gives us a behold to the data principle on the way he can take a control on the data which is moving upon. So moving forward, when we talk about this data privacy, we can move ahead, Nikita. So moving forward and talking about this data privacy, let's try to understand what data are we referring here. So the prominent term which we are referring here is a personal data. Now, what thing comes to our mind when we talk about personal data is it has to be something restricted to an person or something restricted to an individual. Apt, exactly fine. But to get into a more bigger part and get into a wider scope, anything and everything which helps you identify a particular individual can be termed as a personal data. I may talk about your hair color, I may talk about your name, I may talk about your email, and so on. So anything, whatever you say, whatever you use to identify a particular individual would fall under the category of personal data. To take it more classified way, we have two prominent categories wherein personal data is ideally been bifurcated. I would let few seconds for everyone present in the seminar to have a glimpse upon the types or a minor bifurcation which has been made for personal data. Meanwhile, you go through these personal data components, you could easily see that one part stands about the personal data and the other one talks about the sensitive personal data. Looking on the components present in this both the categories, one thing can be clearly understood that yes, the components which are a part of sensitive personal data are the one which are into a serious nature. As in, the disclosure of these components may hamper personally rights or debar a particular person from any additional benefits are the ones which are included in sensitive personal data. In the case of sensitive personal data, the first category, which is financial data, has been put up in a bold letters, or it's in the darkened font. The prominent reason why we did this part is to make everybody aware, as Pawan Duggal sir also mentioned, like this would be a real game changer even at the top of GDPR. This is one of those reasons. None of the acts identifies financial data as a sensitive personal data, whereas the Indian DPDP Act 2023 has identifying financial data as a sensitive personal data. And not just talk about this DPDP Act, even the SPDI rules which we have currently in place, the 2011 also identifies financial data as a sensitive one. The DPDP Act has also come up with another third category called as critical data, but unfortunately, the government is not quite clear about this data. What could be the critical personal data, or what components could form part of this critical personal data? However, my own personal presumption goes data which might have an effect or which might be critical to the nation's security or nation's threat quite form part of this critical data. Moving ahead on the next slide, what we have is the sources of personal data. So every business or every data principal needs to understand the data collection mode, like in what way businesses come across your data, or in what way the data reaches from you towards the business. The way we have a description of iceberg in the ocean, similarly, we have these two categories of personal data sources. The first one on the left-hand side, which you can see is above the surface data. These categories which are available in above the surface data are the ones in which case or in scenario of these categories, the data subject, or in Indian terms, the data principal is quite very well aware what data is been taken, or this category of data is directly been taken from an individual. Just to give illustration of what would form a part of like demographic data, the address part, the financial data, account statements, balance sheets, so on, health, biometric, sexual orientation data, if there are any allergies, there are any diseases which are going on, and the political affiliations or the criminal history. So the above the surface data is prominently obtained from the data principal, or it is there, or it is where data principal is aware about this data. When we move towards one of the most serious and this category of data, which is evolving from the period of time, here can we move to the previous slide, please, which is evolving over the period of time with the help of technology, we have this below the surface data. The parts or the types which are there in this below the surface data, these are the ones which are backed by highly the technology aspect. So to give you an illustration about one of all, we have this device identifier. We used to get a sign-in message when we log into our very own Gmail account through another device. Now, what does exactly happen? The Gmail identifies like this X person has been logging from another device. So to be double sure, they drop you an email asking you, hey boss, is it you or it's a different person? Moving towards the online identifier, dropping in any website through mobile phone, laptop, or any browser, use your email ID, which is your login ID, and a password help you to online identify yourself, stating your login ID and the password or the combinations which you use togetherly to get yourself identified online. Then you have these social media markers, wherein being a common example, if you go ahead and look for a particular product on an shopping website and eventually you put it the product in the cart and leave it without purchasing, you would identically witness the product or the same product on each and every social media site which you're visiting. So this is where you get socially marked, socially identified on your social media platforms, and they target you with a similar product which you intended to buy. Then you have a metadata, which in literal term talks about data of the data, wherein giving you a simple understanding like Chintan's monthly spending is 10,000 and defining it whether way like in what way 10,000 is spent. Then you have the location data, which helps you in tracking about where the personal travels and in what way it can be offers that can be targeted to the person. And then we have the analytics, which can be internally placed up. So these are the prominent sources of data. Taking a step ahead and just trying to understand what exactly led to this data privacy at such a great level and at such an intense level. So the above mentioned 4 concerns is what we have is the security concerns, the data leakages, the illegal data sharing, data theft, which are happening all around, needs to be controlled, taken care of. Technological advancements, we are witnessing huge amount of among the database have been built up in a way where things are turning, or it might be troublesome for everyone. The privacy law domain, which we have all around the world, going throughout the globe, is putting up. And as Dugal sir very correctly mentioned, the reputational risk which the organizations follow. Taking a step ahead and moving to the next slide, what we have is to offer about the journey of data privacy. So the seeds were sown in October 2000, where we had the mention about this personal data in the IT Act 2000. The 2011 was a level up period for us when we had introduced the SPDI rules, and which identified financial data along with other biometric data in putting up as a journey and getting up some 12 to 14 privacy rules or security rules for the sensitive data. There is a gap between 2011 to 2018 where what I personally term as the Masiha of data privacy in India. We have our High Court Justice Mr. K.S. Puttuswamy, who led a great fought against Union of India to enhance the importance of data privacy against the recent Aadhaar Act, which came up during that time, and which eventually led to the formation of Justice B.N. Shri Krishna Committee, which we could see in the flowchart in 2018. And then post that, what we are witnessing is the constant growth, with first draft of data protection bill coming into 2019. Getting it placed in 2021, and due to some reasons though got withdrawn in 2022, but 2023 we have this DPDP Act. Currently we have this DPDP rules in place, which are expected to get finalized maybe by the end of this year or upcoming year. Moving to the next slide, what I wanted to depict you all are the various prominent data privacy laws which we have around. The GDPR, which was formulated in 2016, implemented in 18. Along with that, we have CCPA for Canada, we have TCP for US, then we have PIPEDA for Canada, Australia's PA, and the latest one in the market, which we witnessed, is DIFC's data protection law. Maybe the one which we are witnessing as of now, the India's DPDP Act, would be a game changer, and it would be acting as a kind of Bible for all these data protection acts. Moving ahead, there are few things which I wanted to introduce about this DPDPA, which are in bit differentiation with the global GDPR Act or maybe the global data privacy laws. So first and foremost, I want to take you to the data principle. The prominently known concept of data subject has been moved to a data principle, wherein by the name principle itself, government intends to give a level of designation to the one who has the data or whose data is getting processed. The data controller, commonly known wide across in the prominent data privacy laws, has been termed out to as a data fiduciary, which would in case give them a more sense of responsibility in working, handling, and taking care of data. The other two definitions of data processor remains same, as in a person who works on behalf of data fiduciary, and the data processing activities, a minute two-word term, but having meaning, continuing and understanding right from the process of collection, storage, processing, utilizing, transfer, deletion, everything gets covered into the word data processing. And last and foremost, the one which we are more skeptical and trying to understand is the critical personal data. Hopefully, we are expecting sooner or the more clarifications about this critical personal data. But as of now, unfortunately, we only know that this category of data would be all those data that government of India would introduce. Like taking a step ahead and moving to the next slide, I would hand it over to Nikita and would request her to take you along to the rest of the presentation. Thanks, Nikita. Thanks, sponsor.
Thank you, Chintan. Now, Nikita, data protection rules and privacy in organization. Can you highlight on this?
Yeah. Thank you so much, sir. Thank you, Chintan, for setting up the introduction and letting us know about the evolution of the privacy laws. So let's straight away jump into the draft Digital Data Protection Rules 2025, which were issued after long deliberations on 3rd of January, and after a lot of extensions, the final suggestions were asked by the government before 5th of March 2025. Now let's quickly take you all through the important concepts highlighted in the rules. So first is the privacy notice that has come in. So one, which is one of the most anticipated parts of the DPDP rules that were expected. So it says that every request which is being made by a fiduciary to a principal asking for consent shall be preceded, or it shall be accompanied by a notice informing the data principal about what is the data being taken and what is its purpose. And other things are how can the data principal exercise their rights and make a complaint to the board. So now there are four key important elements of a privacy notice, which I can explain using an example. So assuming I am looking to access the services of an e-commerce platform. So the way a privacy notice technically needs to work under the DPDP is basically my name, phone number, address, email is something which is required to be itemized. That these are the details being processed. Next is what exactly is the platform going to do with the data. Third aspect is an itemized description of the goods and services that will basically mean all of the services that the platform is expected to provide us. Then again, notice needs to be clear and independent. It cannot be hidden in the TNCs like it used to be done before. And it has to provide a mechanism of how easily consent can be withdrawn and how a data principal can exercise its right. Moving on to the obligations of a consent manager. So this is supposed to be an interoperable platform for helping data principals to provide their consent. It is quite similar to the account aggregator framework. It is a regulated activity which requires pre-authorization from the data protection board. So there are certain transparency, disclosure, and eligibility requirements which have been set out, like it should be a corporate and it should have a net worth of 2 crores. Then the consent managers have to avoid any conflict of interest with the data fiduciaries and ensure there is no employment ties with the fiduciaries. Now, what the consent manager does is basically it has to enable all the data principals to give consent for processing their data. Now, all the records of the consent which has been given, denied, or withdrawn, the notices and data which has been shared must be maintained by the consent manager, and it has to be accessible to the customers. One important thing here is that the consent manager needs to maintain data blindness to avoid reading the personal data. What it means is they cannot have the ability to store or run analytics on the data. Now, next is this is really important from business perspective. Now, industry was expecting an ISO-like standard to be called out. So the good and bad part here is that there is no specific standard which has been called out, but they have certain standard practices, which is the minimum basic requirements which they have introduced. Like there is the concept of virtual tokens, which has come in place, like an Aadhaar verification through DigiLocker, or maintaining adequate, security measures, ensuring backups, etc. These are access control. These are some of the things which have been notified. So very importantly, it also includes appropriate provisions and safeguards in the contract which you have with the data processor. Now, definitely it is mandatory to have a contract if it is a fiduciary and principal relationship. So ensure that you have, contractual installations and provisions in place. One important safeguard here is retaining of logs and data which are called upon for an investigation for a period of 1 year. So in case there is an incident, you have to keep the logs for 1 year unless any other law talks about it differently. Interestingly, this direction had come in from the CERT, that is a Computer Emergency Response Team, about maintenance of data logs for a rolling period of 180 days, which in India is already in place, but now there is a different requirement for maintaining data for 1 year. So let's see how this shapes up in the final rules. Next is, what are the best practices? So there are a number of privacy compliance tools that can be used for, maintaining the security of the data, like anonymization, authentication of the user, identity management, etc. But what are the best practices which we can follow is, firstly, privacy should be considered through a data project's life cycle, basically embedding it into the privacy, into the design, the architecture and the operations of the systems rather than treating it as an afterthought. Next, very important, it is to conduct a privacy risk assessment first to identify what are the potential threats which can be proactively addressed. Next is employing a data security solution that helps you to automatically identify and apply sensitivity classifications to data to streamline the data access policy. Then minimization basically restricts the data collection, its storage, and usage for specific purposes. Also, it establishes retention limits. Next is continuous data monitoring. So basically, it's a necessity. Keeping tabs on user activity, the query histories, changes to data over time can help detect, anomalous behavior and raise red flags before they spiral out of control. Now, uh, are talking about what are the requirements to be done in case there is a breach. So the next thing is intimation of data breach under the DPDP. So in a nutshell, it is a three-prong approach. This is very critical that in the event of a breach, you are required to immediately go to the Data Protection Board of India with certain set of information which have been highlighted here in the deck. Basically, it includes the nature of the breach, what is the timing, location, extent of the breach. So this within 72 hours, or longer period if it is permitted by the board, you'll have to go and give a detailed report. So trust me, in 72 hours, organizations can really face an uphill task to provide all this information. The next is the data fiduciary also need to inform the affected individuals immediately. So in a nutshell, within 6 hours, you have to go to the CERT to report if it is involving a cyber incident, and if it is a personal data breach, you have to go to the affected customer and the data protection board as well. So basically, you have to give a detailed report. Now, next very important, which the rules have come up, is the verifiable consent in case of data being processed for children and persons with disability. Now, this is very important from logistics perspective. You need to obtain a verifiable consent for processing the data of children or disabled persons. So when this act came, there was a lot of traction, especially for companies which generally deal with users at such a large scale. The rules finally elaborate that fiduciaries must implement measures to ensure that a verifiable consent is obtained from a child's parent. So under this rule, basically, to obtain a valid verifiable consent, fiduciaries must verify if the person accessing this services or platform is a child. Now, if it is a child, the identity and age of the child's parent must be validated by reference to details of identity and age, which is available to the fiduciary already, or it can be taken using virtual tokens issued by government authorized entities like a DigiLocker. Now, for disabled people, again, verifiable consent is to be taken from their lawful guardian, and this applies in cases where that person is suffering from a mental or physical impairment, which hinders their capacity to take a legally binding decision. Again, fiduciaries must do a valid due diligence here to ensure the guardian is validly appointed under the laws. Now, these rules specifically exempt two categories. One are the clinical establishments, or the healthcare professionals, a child care center who are working for the health of the children and the interest of the children. Second category is based on the purpose for which the data is being used, is basically the performance of state functions like state is providing benefits. But again, here the purpose is supposed to be restricted for only the specified purpose for undertaking this activity. Now, next is moving on to the minimum retention period, which are specified. So, one of the rights which is given to the data principles, which I'll press upon, is the right to erasure of personal data. So, in the upcoming slide, we'll discuss about the rights which are given to the data principle. But here, the fiduciaries are obligated to erase all the personal data upon occurrence of two events. So the first event is where withdrawal of consent is asked by the data principal. The principal himself tells you to delete this record, and the second is the delete the consent, and the second is where the specific purpose for which the data was collected is no longer being served. Now the exception is to this rule is where retention is required under law. The Act also explains when the purpose is seen to be fulfilled or no longer being served, or the cases where the customer has not approached the fiduciary, that the data can be deleted after giving a notice of 48 hours. These rules also provide us timeline for legitimate period. Now, this is only for specific classes of data fiduciaries which have been notified in the rules, like a social media intermediary or an online gaming intermediary or e-commerce entities. These have been specifically called out, wherein they have to maintain record of 3 years for that specific purpose. Now, if we go on to the next slide, so as Chintan had explained in the previous slide, what is a significant data fiduciary. So we are aware that the significant data fiduciaries are required to conduct the data impact assessment and analyze their algorithms and due diligence measures. But one obligation which I would like to highlight upon is that the significant data fiduciaries, there may be some sort of a data localization requirement, or some restrictions for the transferability of data for certain classes of personal data. Now, these requirements will be notified by the government separately as to what are these classes of personal data. Now, this again has a sport controversy into due to two things. First is, this could mean that there can be segregation of data that is required by a significant data fiduciary, because we already did away with the concept of sensitive or non-sensitive personal data. It was no longer defined in the Act clearly. And second, more obvious one is a departure from what the Act says, because the Act allows free transferability of data, except only to those blacklisted nations which the government would specify. These were the only exceptions to the rule, but now this is creating some sort of carve out. So, subject to some transfer restrictions. So, but this is just a draft, and let's see how the final rules, shape up. Next brings me to the final provision, which is the cross-border data transfer. So now central government has retained this power to notify about certain restrictions or conditions for if you have to share your personal data with foreign states or their agencies outside India. This again is something that we have allotted that fiduciaries could face a lot of challenges here, especially the ones who are processing data in India for customers who are based outside India, as again they'll have to reconcile obligations under foreign laws that require disclosure of personal data with government agencies. So again, this is a new one. Next is the finally, after the provisions which have been set out, there are also certain rights of the data principals. Data principals are, people like us who are giving their personal data to the organizations or different entities. Now, what are the rights? So let's discuss. This is a limited, less contentional aspect. So quickly taking a recap of what these rights are. First is the right to seek all information that has been processed, to get identities of all the processors and fiduciaries with whom this data has actually been shared. We can ask for the data or the data fiduciaries with whom the data is being shared. Next is the right to grievance redressal. Then we have the right to correct our data, update it if it is incomplete, and also erase our data. We also have a right to nominate any other individual in case of death or incapacity. So now these are broadly the rights. So moving on, how these rights need to be exercised, basically what measures do fiduciaries need to adopt. So both the fiduciaries and consent managers are required to publish on their website or the apps which they are using how a data principle, like how can we access and exercise these rights. Similarly, for grievance redressal, they also have to require to disclose the response time within which they will get back to us. But here, interestingly, in the rules, there is no timeline which has been prescribed. So it is sort of left with the fiduciary, which I think is again very pragmatic. So everybody should be able to decide, but at the same time, the timeline shouldn't be indefinite, but it should be reasonable. So let's hope the final rules also come out with certain definite timelines. So now, privacy in organization, let's quickly move on to what an organization needs to do for following the privacy laws, or, abiding by the regulations and building a privacy culture in their organization, having seen that, how can these rules be impactful, so impactful, and bring changes in your organization. So basically, first is the visibility mapping. So it is basically a data inventory and mapping. So keeping a track of all the personal data that is being collected, processed, and stored in your organization. So you need to carry out a detailed exercise to understand what is the state of personal information in your organization. Next is the privacy policy of your company should define the management objectives, and what are the directions by the senior management to for privacy initiatives. So to comply with the India's privacy laws, businesses should adopt the principle of privacy by design, as I had already highlighted in the previous slides, for building a privacy culture. So privacy must be embedded into the core operations of the business. then there needs to be a track of the regulations to set up the necessary processes. So basically, how to manage the consent. So ensuring that the personal data is processed based on a user consent. There must be facilitating mechanisms that allow individuals to exercise their rights under privacy laws. So you need to shape up your or build the measures accordingly. Then, very importantly, managing the contracts. So, your company may use a number of third parties for processing their personal data. So, all of which must have roles and responsibility defined in terms of consent management. What are the liabilities of each of the parties for the personal data being shared? Next, very importantly, is the purpose bound usage. So, organizations also need to build processes and controls. So, basically, to ensure that access to personal information is restricted only to those who have a business need for it. Further controls need to be established to ensure that the personal information is used only for the purpose for which it is collected. Now, ensuring data security and training. So, privacy and security are closely intertwined. So organizations must have robust security controls. So basically, to achieve all the security measures which we had discussed, organization senior management as well as employees need to be made aware of what are the privacy laws, what are the expectations from each employee, and there must be appropriate trainings periodically, not just once but periodically, which needs to be provided. Last is the incident management. So we have already seen what is supposed to be done in case of a breach, but to manage such privacy incidents, a formal process needs to be put in place for reporting of data breaches to the board as well as the data principal. What is the action supposed to be taken to strengthen the controls and to ensure that we need not make such repetitions or repeat such breaches in future. Now, next slide, which Duggal sir has, already touched upon, is basically the huge amount of penalty which can be levied to your organization in case there is a breach. So there are huge penalties that an organization may face. Now, this is depending upon the gravity, the seriousness of the breach, and what is the provision which has been broken, and what is the repetitive instance of the breach. So this can again range from 50 crores and it may extend up to 250 crores, which is a big amount. So basically, coming to the end, why are we highlighting that privacy or data protection laws are actually a game changer? So, following privacy laws will not only save you from the enormous financial loss due to penalties, but it gives a standardization to your organization. Given the nature of large personal data handling, you'll get a thorough overview of the risk involved with the personal data handling, and you will work hard on the compliance part, which will eventually help in enhancing controls and gaining people trust in your company. So if organizations don't know where their data is, who has access to it, and whether it is meeting regulatory standards, they are already at risk. So businesses that fail to adopt data governance are likely to find themselves locked out of all the key markets later. So yeah, that is it from my side.
Okay. Thank you, Nikita.
Thank you so much, sir.
You have given all the detail and very well presented in this. Now, we have learned, we have seen the Pawan Duggal has discussed, Chintan has given the law evolution, and Nikita has given the main point. Now, I just request Ravi, because Ravi, you are aware sometime, like I gave you example in the sine theta and cos theta. And I was reading this in the jokes that one student is asking from the old teacher, sir, you have taught me so many things, but ये कभी आया नहीं मेरी life में. But when I was yesterday reading article, so I was also laughing when I read this. But I realized this, that yes, because your knowledge is not there, that's why you are not understanding what is the impact of this. And sometimes what is happening, I think this is not my area, so I'm not bothered. Lawyer is also sometimes think this is not something I have to put more efforts on the law part. And people are thinking this is a compliance, so we will do compliance. But now when we see that it is not a compliance, it is a part of your strategy, because penalty is so much and so high that you can't uh, you can't manage this. That's a simple point. So Ravi, in the practical life, what is happening? We have heard the name personal data. What is this data which uh, the case law, whether the things, the point of reputation, the point of compliance, which in the decided case, which in the market, where the other jurisdiction has taken action or companies are losing business, just explain some by case law.
Yes, sir. Thank you so much. So I'll be speaking more on the case laws. Maybe I will mask off the details that should not reveal the personal details, as we are talking about personal data protection. But I'll give examples of what transpired and what really entailed bringing of this law, but from a precedential law point of view. See, well, if we talk about what is the need of legislating for protecting personal data, I read a quote yesterday. It was a ad banner that was put, big ad banner, and it says, "We did not come so far only to come so far," which means that it will not stop here. The world has evolved, it will evolve. Data is the new lifeblood. It is a new asset class. It was recognized back in 2011 by World Economic Forum. And there is a whole history starting from 80s when OECD was formed, and there is nearly 45 years of development so far. You talk about data. When we talk about understanding the data and how it impacts, you see, even if a company is attacked, let's talk about a company which is rendering consultancy services, or let's talk about a law firm. A law firm is rendering services to its clients, handles confidential data. Some employee of a law firm takes away that data, misutilizes it. And there is a case on this point. I'm not suggesting there is only one, there are numerous, but there is one which needs highlight from Bombay High Court. There, all the pricing detail, all the client data, everything an ex-employee took away and started misutilizing it. Apart from it, started soliciting the employees of the employer to his new place of employment. Bombay High Court came down heavily and used injunction to stop it. Then there is another famous case where Google was hosting some photos of a celebrity kid, to which objection was taken because the photos and were in the technical language, it was a non-consensual intimate image, and therefore an objection was taken. Google was directed to take down the photos outside the court, but they did not take down the photos, citing that the intermediary guidelines did not allow to take it down, because freedom of speech is another competing factor when you talk about privacy. So ultimately matter went to court, and then those photos were taken down. I'm talking about an era when this law was not there, but there were nevertheless provisions under which one could deal, chiefly the Information Technology Act and the sections and the precedential law developed thereunder. So that could be resorted to. Talking about data breaches, I think there is a robust body of experience behind legislating this, not only in India, but worldwide. And none other than the joint committee on this on this very act lays down under the head biggest data breaches of 21st century, a list of data breaches that have happened, which have led to the sovereigns and governments across the globe believing into investing and erecting an infrastructure to protect data crimes. Now, I'm sure all those who are in the audience as well as on panel must have used Adobe. Adobe was attacked and all the login data and undetermined numbers of user accounts were stolen. The overall impact was around 153 million accounts were impacted by this breach. Talking about Canva, uh, uh, another very popular app amongst professionals and general public alike. There also user data, personal data was exposed, and the accounts that were impacted were 137 million. So what I was saying in the beginning, even if the attack is on an organization, the personal data handled by the organization could be indirectly attacked. And this direct and indirect theory is not new to the legislature. There are umpteen number of laws where the fine distinction between something that can be done directly and how it can be done indirectly, and how both direct and indirect should be prevented if the nature of law is peremptory, which puts prescriptions about what not to be done and how to ensure that no mischief is played by anybody. So you see that we just discussed Canva, 137 million accounts were impacted. Coming back to the Indian diaspora again, there was recently a case where Star and Allied Health Insurance was brought into rings. A writ petition was filed alleging breach of data, alleging that data was sold by one of the key employees of the company. Ultimately, the writ petition got dismissed, but the concern, and in prior point in time to that, there were other two insurers about them, similar sort of concerns were raised. So even you talk about either global landscape or Indian landscape, you see these, apart from the retail level hacking that really happens, cyber criminals or the leakages that happen, it happen in a more institutional way. And what I mean by that is they know that instead of going and leaving tracks at millions and millions of accounts, they attack the repositories where all those data is stored. As you can see, Adobe was attacked, Canva was attacked, eBay was attacked, LinkedIn was attacked, and the accounts impacted were more than 165 million. Marriott International, MyFitnessPal, MySpace, NetEase, Yahoo, and in the case of Yahoo, the impacted accounts were more than 3 billion. So this is why they are saying that please put your house in order, please do compliance, because data security is not only personal security. If data belongs to people and peoples create a nation, they create the citizenry. Data security is national security. They can't be separated. And this is also espoused in the Joint Committee report on the personal data. It is now Act. At that point, it was bill. So it is espoused in the committee report. Therefore, the need of this law and its implementation cannot be, obfuscated, or I don't think so. It would be a fine line that will be drawn if only the law is delayed or not implemented with full vigor, worrying about the operational frameworks, or that it will increase the cost of compliances. Because we must all remember that we did not come this far only to come this far. The growth is more. We have a long journey to evolve and cover. And there must be frameworks to ensure the trust and sanctity of data, which will ensure the overall trust in the commercial world that we all have created over the years. And so that it is sustainable. I think this is also part of, should be also viewed as a sustainability aspect of the commercial world overall at macro level. Because otherwise, nobody would be well, I do not know how much bargain people have, including myself or any consumer for that matter, that how far they can afford not to share their data, because virtually you cannot survive the modern world without sharing data. That is a necessity. But the other hand, that should be protected, and it's a sovereign duty. Almost all countries that have a formalized constitution and those that live by rule of law have this inherent duty of protecting the privacy of their citizens. So therefore, this is an important aspect to cover. So that's all from my side, sir.
Okay. Thank you, Ravi. Thank you very much. Okay. So now we have discussed this issue. Let's have question answer session. Okay. So before this, some of them are asking their presentation. So please give. Okay. Ravi, you have given an example. So that question is also, Nikita, tell me, what is personal? Which are,
Yeah,
yeah.
so continue.
No, please tell what is which are personal when we say personal data. So the definition of personal is how far we go and what we cover on this.
Yeah, so sir, basically the act defines, data can be anything. It can be any information, facts, opinions given by a person. And personal is by the means, you can identify that personal through that data. For example, it can be your name, it can be your, phone number, your email ID. So that is, personal data. It can be your passport number, date of birth. So again, in a lot of countries, there is bifurcation of personal data, wherein data is bifurcated between sensitive and personal data, as Chintan explained. But here in India, currently, the rules or the act has not bifurcated that type of personal data. It has just defined that anything which you can, which will help you to identify that individual, as I explained, could be name, address, your passport number, email ID. So yeah.
Okay. Now, why do you think digital personal data protection is a game changer for Indian business and citizen alike?
Yeah. So
Yeah. Carry on. Nikita, carry on.
yeah. So in India, there was, recognizing the need for a legal framework. There was a need to a legal framework to regulate the digital transaction. So Indian government had enacted the IT Act for regulating e-commerce and e-governance, and it had in 2008 expanded its scope for criminalizing identity theft, phishing, etc. But data protection as a concept was introduced that time also. It was only for the sensitive personal data. So there was a comprehensive and unified data protection law was long overdue, because of which various sectoral regulators had come up with some of the data protection laws, like RBI. Just for an example, RBI mandates the data localization, the telecom regulatory authority also regulates data privacy, but there was no comprehensive data protection law in place. So now that this law has come into place with such a big impact, imposing such enormous penalties, the organizations, and it is applicable to all the digital personal data, and the percentage of the digital transactions handled in India is too high now. So there was a need of the data protection law to come in place. So now the organizations have to pull up their socks and maintain the data, establish their independent team to dedicated for the data protection laws, for preparing strategies, how to manage and report the incidents. They have to build their company's infra and operational processes for how to collect the consent, processing, and provide notices, and all the systems need to be in place, because now finally we have a law which is going to regulate our personal data, which was earlier not in place.
Okay. What are the biggest challenges organization will face while implementing DPDP Act, Chintan?
And thank you so much for that question, sir. So prominently, what I believe the biggest challenge we have around is the population. The number of data principles which India would be coming would be hundreds of crores. So even if I take an example of a social media or other social shopping giant called as Flipkart, there would be on an average around 30 to 40 million users on the Flipkart. So what if tomorrow rules come up and Flipkart is required to give them their rights? How would they deal? What if 20, 20, 30 million, 40 million people come together, raise their rights? How they would be able to get them? What would be the eligibility standard timing they would repeat? What would be the workforce they would be putting up? And at this level, when we're talking about the giants. What about MSME businesses? I am a bit worried about those businesses where they don't have that equivalent amount of capital to put up, equivalent amount of funds to invest. So practical implications is the prominent one, which I believe. Along with that, awareness among the people, that building of technology to handle this quantitative amount of request, those might flow up. And a basic thing which I feel inculcating this in the common parlance and generating the awareness would be a practical challenges. That's what I believe.
Okay. Now you have done your course from Europe. Okay.
Yeah, the IPP one.
How
Yeah.
does the India DPDP Act compare the global laws like GDPR, EU, CCPA, USA, and PIPL, China, or any other jurisdiction?
So very honestly, it's not the love for the nation which is coming up ahead, but I firmly believe that the India's GPDPA would be superseding each and every one, because the level of intensity, the level of minute details what India's data privacy law conducts is far further ahead of the GDPR and other ways, right? Even if we talk about the terminologies, the thought process behind giving up the terminologies, that is quoting a data subject as a data principal who is a level up and replacing data controller as a data fiduciary who increases the responsibility upon the controller part, shows a biometric form like how things would be happening. Also during the session I had a mention about the financial data, like no other data privacy law around the globe considers financial data as a sensitive data and asks for a utmost care on that. That's a prominent one. The only thing which we as a country would require to implicate a strong privacy culture, like when I was witnessing the data privacy culture which we have amongst the Singapore, even in the school level, whenever a personal data gets circulated over the WhatsApp group, they prominently use the delete function. As in, once an image has been circulated, which has a mention of the kids, roll numbers, and so on, once the project has been completed, group gets resolved, the data gets deleted, and the sentence has been forwarded like your data has been removed. So culture is what we lack, but the law point around, the provisions point around, we are superseding. I have just a small regret, not a regret, a complaint kind of thing on the Article 32, which gives the immense power to the government on this personal use or intercepting the personal data of any individual. I believe we can put a close or we can put some control over the governmental aspects the way European data protection authorities does. Like they never supersede, they never let this government supersede over this data protection authority. That's the only critic point from me, sir.
Okay. Do you foresee India achieving data adequacy status from EU with this law? What needs to be addressed to reach this extent?
Okay, so prominently considering the level and the quantity of data principles we have, we would be doing it because a lot of Indian companies currently have their subsidiaries outside India, in Dubai, in US, in European regions, wherein they are already practicing this kind of this kind of data privacy requirements. But the only major chunk of problem which we will be facing are the core Indian-based companies, which hardly has their presence outside India. So for them, it would be a challenge. But putting up and talking about the multimillionaire giant, it won't be much challenging part for them to adopt the same practices and get it universally accepted. So yes, adequacy, I know we would take some time though for the confirmation of that, but sooner or later we can expect to be data privacy adequate. Like we are always achievers in every sector. So sorry, sir, you're on mute, so I'm not able to hear.
Okay. What best practices, Chintan, from global jurisdiction can India adopt to strengthen enforcement and citizen trust?
So inculcate data privacy within the younger age, maybe schools, high schools, colleges, universities. Maybe a chapter could be introduced about this prominent laws practices. Transparency, another key which can be expected now, though we have this RTI prevailing in the country. I barely know few people around me who are using this RTI, the services. So initiating awareness, getting up through media, taking up towards places around. And I believe, sir, a concept called as awarding. Awarding concept could be introduced, as in where we can award people who follow such kind of activities very diligently, take the data privacy care utmost, and so on. Maybe various webinars like what we did today could help us taking a lead towards this development.
Okay. Nikita, are the concept or deemed concept and legitimate use prone to misuse in the absence of strict definition?
Yes, so thank you for the question. Yes, the act and the rules have spoken a lot about, legitimate use and giving certain powers to the state government and the central government. So I think there have been too much levy which has been given to the government, considering that, there were some powers which already existed under the Telecom Act, and also we had law enforcement agencies can seize our digital devices. So these rules provide a lot of exceptions to the state authorities for various reasons, like providing subsidies or benefits, and also the obligation for erasure of personal data does not apply to the state. Now, at the time when Aadhaar was also introduced, it was only for the welfare benefits. Again, referring to the Kutuswamy judgment. But here the scope is much broader. And in spite of Act's intentions being data minimizations, due to the legitimate use exemption, we will tend to overshare. Now, again, as I said, this conflicts with the Puttuswamy judgment, and this again is very open ended, because if our data is being used for, in the name of integrity or sovereignty, nobody is going to inform us what the national security purpose is, and there is a fear of becoming a mass surveillance countries. Also, here in the rules, they have mentioned straight instrumentalities also have these powers, but they are not defined. So it may include anybody that carries the state or government operations, or they operate under government control, or it could even be the public sector companies or law enforcement agencies. So yeah, naturally, but the concept of data minimization or the data principle, which was the requirement why which the act was or the rules were put in place, is going to get diluted because of over data being shared with the state or the central government.
Sir, I am a partner in a practicing CA firm wherein we receive data from the client for various purposes. How would it affect us and what we need to do about it? Or I should refine the question. All consulting firm, whether law firm, CA firm, CS firm, or Big Four or law, they are receiving data of the client. Now the one is data they are receiving. So in data they have three things. One is they about the client. Second, about their case law. Like they are giving an assignment that they want to acquire some company. And then you are discussing with them and putting everything in one block. They are asking any opinion. They are asking any case they should be filed. So what they should, how this will affect to these consulting firm and law firm, and what they should prepare. Kanikta.
So again, for any consulting firm, the Act very clearly says that it will apply to all the personal data which is there in the either the digital form or it is taken and then digitized. So now we organizations, law consulting firms, we maintain these systems wherein we are maintaining the client records, what are the clients' requests and everything. So again, here the requirement for abiding with the data protection laws will apply. The consulting firm will need to establish a process for taking the consent of the customers, for giving them privacy notice, with which should have a detailed description of what is the service, or like the consulting service for so and so purpose, for a merger, acquisition, or any purpose for which the client is requesting. That services needs to be defined. Then what is the data, the company's financial information, or administrative information, registration certificates, what is the data which will be taken, and with what all agencies, or because we as a law firm, it may also outsource or use the services of a third party. Then we'll have to maintain that information, and in case that company asks us what all information has been shared with whom, or we'll have to be ready with all those processes. So and establish again security measures for handling that data. Again, for the third party services which we are using, we'll have to develop our revisit our contracts, our agreements which are there with the third party, to ensure that we are properly insulated and there are proper rules and responsibilities defined, because at the end it is the fiduciary who is collecting the personal data who will be responsible or accountable. So yeah, these systems need to be placed even for a consulting or a law firm.
Okay. What all steps should an organization take to ensure compliance with DPDP Act? Major step to start with. Nikita and Chintan, both you can add.
Okay, Nikita, I'll take that one for you.
Yeah.
So when we talk about this DPDP part, the prominent step we should start is identifying the classes of data, or rather the category of data. So what category of data you hold? Either your organization is dependent upon the public data, which is available in public domain, or it's a personal data. Get this classification. Try to understand how you are collecting the data. What are the sources where your data comes across? Once you identify the sources of data, take a step ahead and go and check whether the data principal whose data you are collecting through various sources, is that data principal aware. If the data principal is aware, that means you're already telling him, you're already giving him a notice, ki boss, this is data of you we are collecting for so and so purposes. If the person is not aware, which clearly denotes that you are lacking the notice compliance requirement, go ahead, put up a notice depicting that, yes, boss, these are the components of your personal data we are collecting through so and so source, and we would be processing for through source. Once data collection has been done, try to identify the access controls that you have been put upon those data. As in, what are the team members who can look through it? Is there a particular data which unnecessary sales department is getting through, or what? Try to restrict it. Even on the person who has the control on it, go ahead and check whether you have read control, write controls, or both read and write controls. A basic kind of ROPA requirement, that is record of processing. Once you're done with the record of processing, then you have a theoretical picture in front of you, as in what kind of data you have, where do you store, from whom you get, and what level you get. Then comes the part of processing, where you go ahead and check, yeah, this is the category of purposes for which I'll be processing this amount of data. Restrict your use of data only for the purposes for which you have been collected. If you might be requiring you to use the data for some another purposes, which is in line with the original purpose, you may be doing that. You are allowed to do that. But if there is a great deviation between the purposes for which you have got the data and now the purpose you're thinking to use it for, then you may not be allowed to use. Post putting up for the purposes, check who all are part of processing the data. Either it is just you have a subcontroller, you have a processor, you have a joint controller or a joint data fiduciary who you and along with that fiduciary togetherly deciding what to be done with the data. Identify, check the vendor agreements. Do they have data protection clause, data privacy clause, non-disclosure clause, retention clause, and everything. Ensure you get a certificate from all your vendors at the end of the relationship stating that, hey boss, since we are done with the relationship and I do not have any other regulatory requirement for storing the data, probably I am deleting the data. Get it certified. Look for your retention standards. What time limit, what are the applicable statutory laws which are asking you to keep up? Is AML asking you to keep for 8 years? Is RBI asking you to keep for some more years? Is income tax asking you to keep for so and so years? Go through that, check whether you are abiding by that. Once you're done with it, maybe you can go with all the multiple encryption methods as well as anonymization methods and get rid of the data. So that could be an entire flow of how data can be dealt with the DPDP compliance part. That's it. That's it from me.
Nikita, your side, anything you want to add?
Yeah. Yeah, just to add, Chintan, I think you explained the concept of, identifying the vendor agreements and what are the clauses to be included. One thing which I would like, which organizations can already start is to have a privacy notice in place, because we are expecting the rules to finalize, shape up, and the act to be enforced, with final rules to come in by the year end. But again, this is something, privacy notice is something which will not be which will be there in place. So the organizations can start preparing their privacy notices. Luckily, there is no format which has been prescribed by the regulator, by the MEIT, but there is they have given certain requirements. So I think one thing which organizations can shape up is the privacy notices. They can start to think how can they build systems with their third parties for identify with whom are they sharing their data, and what all controls need to be built in place, because this is something which, when it comes into the final position, that time would be too less to make such a big change. So these are something like privacy notice or identifying vendors and developing systems with them. We can already start building.
ये कर दिया? Okay. Sorry. Yeah. So, Nikita, there's a one question. Legacy personal data refers all personal data with companies, etc., prior to the act becoming effective.
Yeah. So, for the legacy personal data, what has been defined is, the rules have clearly said that for all the legacy customers, though going forward, whenever you have to process a customer's data, we'll have to take the consent for
But
each
Nikita,
purpose.
first tell what is legacy data?
Legacy personal data is, prior to the act. So basically, this act has come into 2023 and rules have been come up now. So whatever data, personal data is being maintained by the organizations prior to the act, that is legacy personal data. And now the rules have also said something about the legacy personal data, is that the consent requirement will apply to the prospective customers, whatever customers are going to come from now on after the act. But for the legacy customers also, we need to issue a notice to them, mentioning whatever data has been taken, whatever personal data has been taken, what has it been used for, and what will it be, what will the organization do for that, and also what are the services which we are going to provide. So though the consent requirement will not apply, but the requirement of a notice will apply to the legacy customers also. prior to the act.
Okay. Now, how should companies prepare for compliance in the absence of finalization rule under the Act? Because it's a proactive point. Rules may come, rules may change. So, Chintan, what is your view?
The point which Nikita is constantly stressing upon notice, I feel that should be the undisputed baby steps that can be taken, along with that categorization of the data, trying to understand. And one more thing which companies need to understand, that this refers to a person, that is an individual. So we should not go by the definition what we have in Income Tax Act or other way around. The person, as per the data privacy laws, is a living individual. In certain cases, it can be dead as well, but it has to be restricted to individual. Identifying the data, identify whether the data is already in the public domain, checking and distribution of the data in these categories, awareness, self-awareness within employees, making them aware about the law. Though we have this India's DPDP coming up now, almost 40 to 50% of the India's DPDP has been covered by either of the other jurisdictions which are smoothly running around the world. So employee awareness, the nature inculcation part, trainings can be prominent part of one, maintaining records, taking care of the obsolete part, or taking an action over the data which is already available with me, the legacy data, which was the previous question discussed, in what form it is, how it would be stored, whether we are required to store, whether the purpose has been done, and the actions which were taken post data. The data localization part, even this point was quietly stressed in the session. Like what is the amount of data which is getting processed outside India? Is it processed in the country which has adequate data privacy regulations, or we are sharing our data to the servers which is there in a country which might be vulnerable for us? So these are the prominent baby steps which can be taken without even having a wait for the rules, which would be in itself be strengthening the data privacy practices the company wants.
Chintan, one thing which I would like to add to what you said is, this is a very important point from a security control perspective. Doing a privacy risk assessment is again very important, which every organization needs to do, even if the rules have not come in place, because they have to, identify what are the potential threats at each process level. So they have to assess their systems and processes that deal with the sensitive or the personal data, to have a visibility on how is the data being managed. So again, this privacy risk assessment exercise is very important, and this is something which can be done right away.
Absolutely, the PIs and the DPIs.
Okay. So now, because time is short, so I have to go for rapid round. So you have to give very short answer because some questions are still there. So Nikita, we are hearing the Income Tax Department now can access the social media and other data of the people. How does the DPDP Act plays in this role?
Yes, so the recent bill, this had introduced this provision, but again, here the Act has provided certain exemptions to state and central government. If they want, they can use it for the the regulatory purposes. So it is
So
acceptable.
do you think sector specific impact will also be there, like sector fintech, healthcare, or all laws are common?
Yes. So basically, the act specifically says that it is in alignment. It will align with other acts. It will not be in derogation with the other act. So the other act specifically, if you see the provision which is there for maintaining records, it does says that if there is any other act which have a strictness, it will prevail, and the sectoral regulations will prevail in such cases which are very stricter.
Okay, how should this startup and MSME approach compliance because they have a limited resource?
So, specifically for it will apply to MSMEs also, but the Act has a specific exemption. So the Act says that the central government may notify depending upon the
So suppose they are,
size and classes.
suppose they are
Certain startups are exempted here.
suppose they are saying MSME they have to follow law, but if
Yeah.
the cost, how they will meet out the cost?
Yeah, again, sir, here, risk and cost analysis needs to be done. After first, they'll have to do a retail exercise to identify the risk and what all controls have to be built apart from the ones which are already in place. So
Okay.
again, that risk or cost exercise needs to be done here.
Achha,
But
what
to
kind?
add,
Yeah.
So to add that to Nikita's, government has given certain exemptions or relaxations for the normal data fiduciaries. The prominent responsibilities to have a DPO, conduct risk assessment, maintain records has been bestowed upon the significant data fiduciaries, which would be identified upon the volume of business, develop data process. So I believe the cost and the risk part which will go hand in hand in that scenario. So
Okay, Nikita, now the new role will come Chief Privacy Officer, Data Protection Auditor. So do you think that you can do this audit?
Yes, so the basically this audit requirement applies to significant data fiduciaries. Right now, it is just mentioned in the rules that there needs to be an audit, which is supposed to be done every year by the significant data fiduciaries and the consent managers. It has not been specifically defined who can do the audit and which all are the authorized firms. But yes, I think a CA, basically a firm should be registered under ICA should be able to do it.
Okay. How can an organization turn data privacy compliance into strategic business advantage rather than regulatory burden? Now, today, when there's a law is coming, then like corporate governance, you follow, your valuation will go. Okay, something is there. So there is some law which is prospective or which is giving some enhancement to your value. Some law is restrictive that you can't do this. Normally, these are the two types of law, but some law where the penalty is so much and you have to spend too much money on this and you are just managing the law. That's all. No enhancement. So do you think business advantage will be there if you follow this?
So, one thing which I would like to add upon here is apart from the cost savings, which the organization may benefit due to reducing the risk of, data breaches and regulatory fines if they are in compliance with the law, there are other things also, building a standardized procedure, through the systematic processes. It will proactively help you to mitigate the risk which are there and this if you are compliant with the privacy laws which will automatically build a public trust in your organization and so basically everyone knows non-compliance is costly. You have to incur some cost or it is a risk point if you're not in compliance with the laws.
so you're on mute, I believe.
Okay, so now it's a time because we have a 4 to 6, so it's a time to close this. So before closing, we have a ritual that all the panelists should tell what is the impact of this law in future, okay, and how they see. So 30-second or 40-second you can say. So Chintan, I will start with you about this topic and about the future of this.
Thank you so much, sir. So, as you rightly mentioned, like I understand, being a CA and moving entirely towards the data privacy compliance, that itself depicts a part and prominence, like what magic this would be creating. Since we are at such a huge level and the requirement of the businesses, MSMEs, there would be a lot of data fiduciaries as well as significant fiduciaries in the upcoming stage. There would be a lot of demand for the data privacy professionals, not only helping them out for the India compliance part, but also to help them out with making a merger aspect with their outside the India subsidiaries, giving a guidance stick to the government about how policies can take the ins and out, the problems which would be facing, and also being a part of bridging gap between the government board, the data privacy board, and the company's data privacy team. He would be a standalone part for the data protection officers. Along with that, it would be also playing a huge role in resolving the grievance of the data principals and making the life better. So yes, a very prominent role upcomingly. I do urge a lot of new chartered accountants as well as professionals to take up this data privacy seriously. Like even if you go to the mall, you buy something, whenever they ask your mobile number, have a guts to go ahead and tell them, is it mandatory? And fortunately, they'll upfrontly tell you, no, sir, it is not mandatory. This is a bill and you can move out. Thanks for shopping. So that's the call which I take all the time. And yes, sir, that's it as a closing mark for me. Unfortunately, sir, you're on mute. We're not able to hear you.
Ravi, your point.
I think if data is the lifeblood, this is insurance for that lifeblood. Not only insurance, but also a preventive healthcare system. And it does not stop there. It provides for end-to-end life cycle management of your privacy. So that's important for all the reasons that my friends, my colleagues, and most importantly, Dr. Duggal said in the beginning. I echo all those reasons, and words will fall short if I explain. So we'll relate to Ms. Kothari.
Okay. So, Nikita, what is your call on this?
So I think this has impact on all the stakeholders, be it individuals like us, then on businesses as well as the government and the public sectors. When you see it from an individual point of view, we finally have our privacy rights. Though we have certain rights by the constitution, but we finally have a right, for our personal data. That is the biggest step, I think. We can go and raise our grievances. So, for example, if earlier there was some mistake in our identity card, like a driving license, we used to go to the transport department, but that was not taken seriously. So now we finally have such an authority whom we can go to and raise our complaints. Then again, from a business point of view, yes, there are certain compliance cost, but again, compliance, with the data management practices can help businesses evolve the meeting demands and obstacles which they are going to encounter. And again, it is going to be competitive, and it is going to be a competitive dynamic. So again, there will be competition with the marketplace, considering how businesses can leverage the data protection as a competitive asset. From the government point of view, public sector entities are bound by the same data protection standards. So basically, these agencies will also have to ensure compliance. Like, for example, if we look at certain exemptions for legitimate use, though they are taking, the government is taking the data, but again, they need to ensure the security of the data. And again, it will have an influence on the public services as well. So yeah, there are a lot of challenges, but it is going to be evolving, and we'll have to see how we manage innovation along with compliance and give it a harmonious balance.
Okay. So now Pawan has joined again. I know he's outside the office. Pawan, because before closing topics, I have two questions for you. And second is your concluding remark. Now, first is I have asked this question to Nikita and Chintan also. Now, every law which is there, people are following and give example of corporate governance. You follow corporate governance, your value will enhance. But this law, you are just following. If you're not following, you will have to pay 250 crore rupees penalty, and you have to install system, process, and everything. Cost is there. Otherwise, my life was smooth sailing in a normal business line. So I'm just asking, how can organization turn data privacy compliance into a strategic business advantage rather than regulatory burden, and it can create a value for the organization? That is my question. And second question connected to this, do you think this data protection become boardroom priority as on par with financial performance on ESG and other thing in future? Over to you, Pawan. Pawan, are you in a position? Yeah, please.
Yes, I'm back here. So first thing first, let's make it very clear that let's not take DPDP as a burden. Let's take it that you do compliance, and that becomes your distinctive competitive advantage. You will be able to be in a much more better position globally if you are actually able to show that I am already compliant. You will get more business, more new business opportunities and prospects are going to open up. And therefore, don't see it just as a burden, see it as a business opportunity. Initial investment is much, much better rather than long term, shall I say, losses. That's the first thing. And the second more important thing is that we have to see it from a proactive governance ecosystem standpoint. Data protection, like cybersecurity, will very quickly become a boardroom subject, a boardroom priority. Why? Because tomorrow, once there is a fine against the company, it's the board that will primarily have to be responsible for ensuring that the monies are adequately payable. So the board is going to find that its seat is already on fire. So it will definitely become a board priority the moment the law gets implemented. Already, I find it's a board priority amongst existing boards in the countries. Because why? Companies are saying, look, I want proactively to ensure compliance in order to show that I am much better than all my competitors. I am proactively doing my compliances. Therefore, I'm your best bet for doing further business together. So I believe that's the new mantra. So let's not see it as a burden. Let's see it as a business opportunity to further grow and enhance your business prospects. Thanks.
Okay. So now what is your take on this entire law and message to the corporate world and the practitioner, lawyers, chartered accountant, company secretary, board practitioner, promoters? What message you want to give through when this law will come? What preparation they should do? What are the future things? And how you see the entire prospect of this law?
My message to the corporate ecosystem and stakeholders is very clear. Please realize that you are right now in the center of the digital Kurukshetra warfield. You are actually fighting a battle. The battle is against data protection. The battle is against cybersecurity breaches. You are not an astrologer, you are not a soothsayer. You cannot predict when is the next breach going to happen. So please have an adequate security cover around you. This security cover, this armor, is in the form of your compliances with the DPDP Act, with the IT Act, with the relevant provisions for cybersecurity. Because once you are seen to be on the right side of the law, then the law will go an extra mile to protect you. But if you are not going to be seen to be rightful in terms of your compliances, then your reputation is going to be impacted. You could be exposed to unlimited damages up to 250 crore rupees in terms of fine. Your entire current and potential business prospects could be actually impacted. So right now, please remember, the entire world and the entire industries are at the same level playing field. It's up to you how quickly you can demonstrate your leadership by showing your proactive compliance, and then use this to your competitive advantage by telling your potential existing and new customers and clients, look, come and do work with me because I am compliant with this law, which is going to not only enhance the confidence of the customers, the clients, and the business prospects, but more significantly, it's going to catapult your business onto a new level. Thanks.
Okay. I think you have rightly said. So thank you very much to all. Thank you, Chintan, Nikita, Ravi, and especially Pawan, always our star batsman. And when we were together in law faculty, and he was earlier on television, and we were admiring to seeing his doing law also, study also, and going to the television. So he was our icon that time. That time selfie system was not there. So we were taking signature and we want to just do this. So Pawan, thank you very much. And
Thank you.
I think because in our webinar, it is our 214th 12th webinar. And in all webinars, we try to do the proactive role because reactive is always practice of India. The corporate would react when law is implemented, and when they are asking suggestion, they are not. And when the law will come and something has happened, then they will sue. They will say it has happened. So this is our focus. Today, Amar, we have missed out because of his political compulsion, but he is one of the best politician and parliamentarian, and he has contributed a lot. So I will request Pawan and Nikita and Chintan and Amar to have another round of discussion after a month when something concrete can come and we will discuss. So thank you very much. Thank you all panelists and participants. And friends, as you are aware that our knowledge journey is continuous, and every Friday 4 to 6 is our brand of sharing knowledge. So our next webinar is on 28th March. Faster right issue redefining capital raising by listed company. We will do because there's a new recent law has amended. So we want to communicate to the corporate world what the advantage they can take. So till then, thank you very much. Good night.
Thank you so much.